Well, Land of News. Good morning, everybody, and welcome. I'd like to welcome back a lot of people who have been on a few times before, but especially Bill Turner. And Bill, a lot of people have been waiting to see you on here again, and on a lot of other channels as probably as well. And we have Joe, we have Rose, which has been on before, and our brother down here, Jay, and this lady, Heidi. I haven't seen you before, but it's welcome to Land of News. Bill. It's all yours. Go ahead. They don't want to listen to me anymore. It's all yours. Go.
Okay, guys. Well, I have sent. Thank you, Barry, for inviting us along, and all the others for joining in. If you'd like to have a look at that first document which I've sent you, which is the affidavit. Now, what I'm going to be going through, Barry, is that quite a few over here in New Zealand have stopped paying their rates. Okay, so this is a court case that a Bay Corp, which is a debt collection agency, has brought against me. So what I will show you is some of the things in the document itself, and now through various means, I have discovered many different avenues. And the first thing that I can really tell you is that when you go to court, if you give the judge the law and you give him a court case to uphold that law, he must accept it and give you the same verdict.
Wow.
What?
Okay, now there are several. I'll put them in the chat here, but if you've all got your chat on.
Yep.
Okay, so the
Chat's
first.
on. Ready to roll.
Okay, so you'll see that what I've put in there, and I'm going to put what it means, and I'm going to be a little bit cryptic here for a little while, Barry, but yeah. Now, if you give the judge, sorry, that should have been, that last one should have been two separate ones, application and conclusion. If you give the judge, there is also another one that comes into play. So if you give them the correct ratio and you've given them the court case and you've given them the law, they have to apply it. It's that simple. So if we go through the affidavit now, have you all got your affidavit? You won't have it open, Rose. Oh, you have? Okay. So, special affidavit of John Henry. The language contained and used in this declaration in commercial lien is not to be construed, abrogated, or made repugnant in any way, shape, or form, or to be misconstrued as legal jargon that would alienate the undersigned sui juris state. We, John Henry, unrepresented as a general executor and principal in this matter in our court. Now, here's the first one that you will see, coram ipso rege. Latin meaning before the king himself.
Nice.
Okay. So that's in our court. Having attained the age of 21 years on the 3rd of March 1969, of sound mind and competent to verify, now make this solemn declaration, believing the same to be true, certain, complete, not misleading, and declare that. Okay, now I'll let you go through these yourself, but there's certain bits. Now, at the top there, we went through our sui juris state, which is a legal maxim that means in one's own right.
Make an inquiry, Bill.
You may.
This document, now, is this a preemptive measure or is this after having been struck out?
This is my defense to the court.
So, yeah, is it preemptive though, or had you been
Yes.
struck out?
Yep, it is. This is to throw his claim out because they can't actually make a claim. Right at the top there, may it please the court, the plaintiff, J.G. Mann, acting malefied. Okay, so malefied is Latin meaning in bad faith.
Mm-hmm.
Now, these legal maxims, the judges must take note of them. If you scroll to page 6, and I have numbered them this time, you will notice, Jojo.
Good stuff.
Okay. May it please the court. Have you all got that? May it
Yep.
please? Okay. The plaintiff, J.G. Mann, acting malefied, which is in bad faith. Now, I love this. Through fraudulent claims and sophistry. Sophistry means a form of reasoning that appears plausible on the surface, but is actually misleading or fallacious. An art of persuasion that prioritizes rhetorical skill over soundness and ethical considerations.
Take that.
Yeah. Do you like that, Barry? Barry.
Barry's not feeling great at the moment, Bill. He's recovering.
No,
Oh, I
he's
put
got
my
a...
sound off. I forgot. I muted myself.
Oh, God, there's Haiti. Hi, Haiti. You were talking to yourself, Barry. Is that common?
Well, yes, it happens now and then, Bill. The only one that listens.
Okay, so but that first paragraph there, the plaintiff, J.G. Mann, acting malefied through fraudulent claims and sophistry, has employed legal jargon and court processes to advance a claim without any supporting evidence, thereby seeking to uphold his malicious claims. J.G. Mann has failed to appear in court with an affidavit pursuant. Now, you guys will have to go through your own rules to find those ones in Australia, Barry and Jay and Rose.
Yeah.
So, affidavit pursuant to Rule 815 and Rule 816 of the High Court Rules and Section 132 of the Evidence Act. As heir, John Henry, by operation of law. Now, this is a very, very powerful statement, because what they do is they use operation of law to get their things across the line. And that's when you present the documents, you don't have to do anything else. By operation of law. And the reason for that is that if this goes through court, which it will never appear on the record. The reason being that it would pierce the corporate veil. And they can't allow that. You'll actually see that. We'll go through a couple of things here now. Rule 5.49, which must succeed by operation of law, ficto sedet veritate. Oh, I like that last bit, titty.
Oh, here we go.
Which means fiction yields to truth. Okay, so they're bringing a fictitious entity into court, but the legal maxim says that fiction yields to truth. So everywhere they go with this, they're blocked. Memorandum there, which is on page 6. We confirm everything in our affidavit is true, correct, certain, and not misleading. And the question, okay, now this, number 2 there, the question for the court is, now when you use that, the judge has to look at the question. Then all you have to do is show him the law and show him the statute, and then he must uphold it. The question for the court is whether the plaintiff has a valid basis for seeking a strikeout in order in relation to the statement of defence and the counterclaim filed by John Henry on the following grounds. The statement of defence discloses no arguable defence. Now, that's what he came at me with. He said, my statement of defence disclosed no arguable defence. And he is right to some extent, because they cannot operate on the private side of the ledger. And the counterclaim discloses no arguable defence. Well, it does actually, but however, we've denied that because a money claim has 5 elements, and all of which need to be proved to allow the order. So everything that goes to court has elements, and they must prove all the elements. God, a bit early to start on the drink there, Hades.
Never too early.
I'm with you, sister.
Oh, you behave. Hey, doesn't she look good, Heidi?
Hello.
Oh, I said she looks great.
She does, doesn't she? Okay, so a money order has 5 elements. The plaintiff must prove the existence of the debt. Now, whenever the council or anyone acting as agents for the Crown come to you, they can never give you an invoice or a statement. What do they give you instead?
A demand, a bill.
That's the one. They don't give them me.
A demand.
No, they make a demand. Okay, so the plaintiff, to allow the plaintiff must prove the existence of the debt. So a written or verbal agreement where one party agrees to pay money to another party. No contract where both parties have agreed has been presented as evidence. Okay, you must, in a contractual situation, you must both agree to it. Quantification of the amount owed. These are the 5 elements that they must prove. They can't prove any one of these, but they must provide invoices, receipts, or other documentation to prove the plaintiff's claim. They can't do that. All they can do is make a demand, and by process of law, keep that top of mind, process of law, they get what they call a judgment, but it's only in their own fantasy land.
Yeah.
Jurisdiction. The claim must be brought before a court or tribunal that has jurisdiction over money claims. Okay, so that's done under the Maritime Law Acts, which is the Prize Courts Act. Timeliness of the claim. The 4th element involves ensuring that the claim is made within the statutory time limits at 6 years. Proper procedure and documentation. They never do that. All they do is make 3 demands, and then by process of law, in their own fictional world, they have judgment, and then they go to the court to have that claim enforced. So I tell them straight in this is my defence here. The plaintiff has failed on 4 of the 5 elements, so I've put them there. At paragraph D, the plaintiff asserts that the plaintiff qualifies as a local authority. Now, this is where you really kick them in the butt here. However, this assertion is incorrect. Specifically, the plaintiff is a registered company, and you'll find that in all your companies over there, Barry, all your local councils and that, they're not only listed on Dun & Bradstreet, but they are also on the company's register. So the plaintiff is registered company as evidenced by its listing on Dun & Bradstreet and is not a local authority under the legal definition provided in the Act. I've given the business address there. The Tauranga City Council is registered in New Zealand's company's register, and there's the number for it there. Now, here's the real kicker. Sovereign immunity does not extend to government actions taken in corporate capacity. So if they're acting as a private company, they have to suffer as a private company. They do not have immunity. They must follow the same rules as everyone else. The plaintiff asserts that the defence has failed to provide case law, which I didn't. I didn't provide case law, but what I'm telling you is if you provide the case law, then the judge must award our defence, which is accurate. However, due to limitations in resources and access to legal databases, we have been unable to locate specific case law directly supporting our defence. The closest relevant case we were able to identify is Commerce Commission Commerce Commission and Viagogo. Okay, so we've given that, and here you'll see the ratio decidendi, in this case, established that a business may be found to be in breach of the Fair Trading Act if it engages in misleading or deceptive conduct. Do you believe the council? Do you believe the councils are engaging in fraudulent conduct?
100% the largest bunch of criminals in this country.
Mafia.
Oh,
Mafia.
are they worse than the politicians, Barry?
And they're bad. They're bad. They're indictable.
It's bad as another. One and the same.
Okay, so what I'm saying there, this is precisely the position held by Tauranga Council and its lawyer, J.G. Mann. Tauranga Council has never disclosed the fact that it is a private company. So, ficto juris non est. Oh, I didn't put that one in. But ficto means fiction. Oh, yeah. I've got the next one. I thought I'd taken all the maxims out, but now. But what they're saying, they have never disclosed the fact that they're a private company. So a fiction it has to fail. The plaintiff has failed to provide material facts or evidence or a true bill in commerce to substantiate its claims. They cannot do that. They've never been able to do it. All false claims avoid ex turpi causa non oratur actio. Got that one. Hang on. We'll get that. No action arises from a dishonourable cause. Oh, I know what I can do. I know what I can do. Gee. I will put this in the chat, Barry.
Okay, Bill.
We come down to 11.
Oh,
As this defence is about our substantive rights, which is section 12.2 of the District Court Rules 2014, applies ex debito justitiae. Now, I've just put that up for you as a matter of justice or as a matter of right. There's nothing they can do. It's as a matter of right. Now, this is something that they've just done recently over in Australia, so this will help you out if anyone's not paying their rates over there, naughty people. The Land Transfer Computer Registers and Electronic Lodgement Amendment Act 2002 amended our titles from fee simple to in fee simple, thereby altering our title from ownership to leasehold. They've done the same thing over there, Barry.
Yes, well, fee simple being a grant of the Crown. Well, the Crown was removed here, so is habeas corpus, so that doesn't exist anymore. Fee simple.
Mm. What's that on top of your head, Barry?
Sorry, Bill.
What's that on top of your head?
Oh, I don't know. Chandeliers. I think there's
No. There's no crown. They took your crown at birth.
They're chandeliers, Bill.
I just want to clarify, Bill. So it used to be in fee simple, which means you're the landowner, and then they changed it to fee simple, which means you're a renter.
Yeah,
no,
well,
it used to be. It used to be fee simple. They've now changed it to in fee simple.
Oh, okay.
Yeah.
Yep.
They were all
In-
all tenants, even if you own your property in Australia. I don't know about New Zealand, you're nothing but a tenant. And if you rent a place out, you're a rent provider. So and you know what? Trying to tell the Walking Dead that you're wasting your time. They have to
Oh,
be in their 50s
absolutely.
and 60s before they listen.
Yeah.
Okay. So section 12 there, number 12, produces evidence, exhibit A, which is my birth certificate. So I'm putting these in as exhibits to the court. A legal fiction yields to the truth. Now, the lawyer does not explain the documents. They just say, sign here, sign here, sign here. So you sign those documents. And the change of address form resulted in our classification as a rating unit with diminished rights. Now, I think I've added those into the document. Okay, I've said at 16, in his submissions to the court, that the lawyer has failed to disclose that a Sedicate trust exists. Okay, and also that he's receiving a secret commission under Section 5 of the Secret Commissions Act 1910. And luckily, I have a court case. In King William and Wilkinson, 1994, the agent failed to disclose material facts and evidence crucial to determining the boundaries, thereby breaching Section 6 of the Contract Mistakes Act 1977, which allows for relief where one party knows about a fundamental aspect but fails to disclose it. So when they do that, everything is thrown out. Fraud is ex debito, sorry. Now, this is the real kicker. When I went to court about 4 or 5 weeks ago, lucky for me, and I think there was about 4 or 5 cases before mine, but in 3 of the cases, I heard him say, I have not seen the deed of acknowledgement of debt. So me being as sharp as a blunt pencil, I raced home and looked up deed of acknowledgement of debt. And oh boy, what a beauty. So this is what I found. If you acknowledge the debt, now in Joe's case, the naughty girl, no, she's a good girl actually. She's been paying $5 a week, haven't you?
I have, yes. Oh no, a fortnight.
A fortnight.
Yeah.
What a good girl.
Well, my dog keeps running away, so they have to bring him back to me.
So how long did that go for, the $5 a fortnight? How long did you pay for that, and have they done anything afterwards?
So they went very quiet because I was noticing them as well. I was asking them questions, and so they didn't do anything for 2.5 years, and I just carried on paying, and then they sent the debt collectors along.
Right. Okay.
But the really cool thing is that because I was sending it to the dog ranger because our dog always runs away, and when it had paid off the dog registration, they put the money into my rates account that was overdue. So they accepted the payment. They took it from the dog people and put it on my rates.
Ah.
Yeah, so they accepted the payment. They made the payment, they accepted the payment. So we're saying that
That's accord and satisfaction. So the
Correct.
accord was the offer of you paying. The
Yeah.
satisfaction was them accepting it. So now, even if it's part payment, they have to accept it as payment in full.
it's done.
No, just take a breath there, Rose, and look in.
You have to let them know that it was payment in full.
Look in the chat. Writing required for discharge of debt by acceptance. You have to accept it. And that's the only thing she has to do now to have the whole thing
Excellent.
written off. An
Nice.
acknowledgement in writing. This is what I've just been explaining. The deed of acknowledgement of debt. Acknowledgement in writing by a creditor. Who's the creditor in this matter? They keep flipping it around, and yeah, you're right, Hayes. They keep flipping it around, and we keep thinking we're the debtor, but the debtor is the birth certificate. We are the creditor. So an acknowledgement in writing by a creditor, Jojo, or by any person authorized by the creditor in writing of the receipt of a part of the creditor's debt. Okay, so if they've accepted anything, operates as a discharge of the debt.
Yeah.
I love it. That's fantastic.
Yeah, it is good.
This section applies despite anything to the contrary in any rule of law.
Any rule of law.
Any rule of law. So we're gonna scroll down on the document to page 11.
11.
And thanks to Joe. Take
Thanks,
a bow,
Joe.
Joe. Take a bow, Joe. Take a bow.
No.
No, it's great. We learn that way. That's fantastic. Thanks, Joe.
Indeed. Okay, so it's not on that one. Anyway, no, it's not on there. Oh yeah, see at number 1, John Henry of Public Trust. We need to change that to inland revenue.
Oh, that one, yeah.
Okay.
Or ATO in our case.
I beg your pardon?
Or the ATO in our case.
Yeah. Oh yeah. Okay, so now with that deed of acknowledgement of debt, that gets printed on the back of your birth certificate.
Oh, I see.
Oh.
Yes.
I thought it was with every filing. So if you just keep it permanently on the back of your death certificate, it's in perpetuum.
No, because that is a financial instrument, that is on security paper.
Mm-hmm.
Okay, so when you put that on the back of a book, you okay, Barry?
Yeah, so I'm talking to my wife. Yeah.
Oh, okay. When you put that on the back of a birth certificate, now, if you go back to 27A in the chat there,
Yeah.
an acknowledgement in writing by a creditor, okay, the receipt of a part of the creditor's debt. If you put on the front of the birth certificate in the top right-hand corner.
Does this deed of acknowledgement need to be scanned on the back like last time?
Not
just stapled, scanned on the back.
Yeah, no, you've got to print it onto the back. Yeah, so you run it through a photocopier. Now, how many of you know that stamps are actually money? You put a $5 stamp. It's in the chat there. On the top right corner on the front of the birth certificate. Now, I can tell you, and I know Haiti can too, that they will never return the birth certificate bond. That goes straight into their own little pocket, doesn't it, Aids? I don't know how many. Yeah, it does. Give it back. No, we can't give it back.
No, they say what bond, what birth certificate? You never handed one in.
I don't know what you're talking about.
Yeah,
indeed. Okay, so when you put that in, but if you put the $5 on the front and they accept it, does that comply with 27A of the Property Law Act? Part payment, bang, it's gone. Now, you will notice that in our paperwork, we do say that we limit our liability to $5.
Yes.
Now, I was lucky enough to find a couple of these. Oh, actually, I think
Excuse me.
Actually, I think you on page 11. I think you gave me that one, Joe. I think. Okay, now if you go to the next page, page 12. This is a very, very powerful thing. I have never been able to find where I got that from, but it's New Zealand Forms and Precedents, and I've looked for that book and I cannot find it again. But bonds are used to secure the performance of various statutory obligations. So that deed of acknowledgement of debt, there's nothing they can do. They've got to accept it.
Beautiful.
Excellent.
Okay, and number C there, that's the electronic instruction. You'll have to find your own. Okay, now we come down to the real nitty-gritty. Page 14. Now, this one, acknowledgement, acceptance, and deed of reconveyance. That's our lovely family shield there. You all on page 14, 15. 15.
16.
Okay, so we'll go to 16. Now you'll notice that on page 16 there, in the court of John Henry, under ex debito justitiae. Oh, Bill, you naughty boy. That's supposed ex debito justitiae needs to be italics. Sorry, guys.
Okay.
That is a legal maxim that they must obey. And once again, I use my just want to update you on what we've been doing, and Joe has really picked this up and is running with it really big time, is Chat GPT.
Yeah.
Yeah, go.
Now, Joe is coming up with some amazing shit through Chat GPT. Okay, so what we're doing now is there's a few of us, Joe, Jerry, me, and Daniel. We've been working on documents, and we'll put a sentence in and then have it corrected by Chat GPT in real legal speak. And boy, does it make a difference. It's getting us to speak like real liars now.
They'll have trouble to spot the truth. Like we can, if you can put 3 chats up against one another to make sure it's correct, because that's the one thing you have to be very careful of, is sometimes it'll send you down the wrong road.
Yeah, I've noticed that too. Yeah.
So I use 3 search engines.
Yeah.
Yeah.
But it's getting better and better, isn't it now, Joe?
Yeah. So the paid Chat GPT is really good because it'll keep all your records, and it's also got a law explorer inside there as well. And so you can set 3 engines off against each other and get the best answer. It's amazing. It's the best thing ever.
Is that a program you download?
No, you just on the internet, Barry.
Oh, fair enough.
Okay, so actually, I'll put them both in the chat for you there. Yeah.
Give the Chat GPT, once you've got the information, you can tell it what sort of writing you want. Do you want it super legal? Do you want it layman's terms? Do you want it like I want it dismissed and I want returning of my property, right? So I'm being quite sort of forceful, but you can get that through in your document really beautifully. Oh, it's so good.
The paid version's got a new feature now too, where you can replace your Google with it. So whenever you've got any question or when you want to look for something,
Yes.
it replaces Google search engine. It's an extension onto your browser.
Oh, nice.
Yeah, that's great.
Yeah.
Love it.
Yeah, I love it. Well, I reckon we've got a really good opportunity because I think it will turn sour at some point, but right now we can really use it for finding the remedy quickly.
You're right. They will make it cost prohibitive in about
Yes.
3 years, 4 years.
Yeah, I think we like ride on the wave of like
Yeah.
when YouTube started
Yeah.
right there at
Yes.
the top, and it's all pretty truthful so far.
It's too good to be true. Yeah.
Yeah, so we have
So
to
they're
make
gonna.
the most of right now and get the information off it, because I've even noticed that some things that when I go back and ask, it won't give me the information again.
Yeah, I've noticed that too.
Yeah, yeah.
I always ask for
Okay, so
downloadable documents and I download it straight away.
Yes. Another really good reference is called Google Scholar.
Mm,
So you can go in there and get
second that.
old writings, and then download them straight away because you can get them for free on there as well. So
Thanks for that, Joe. That's great.
Mm.
I'll use that one. Thank you.
So my researcher has been doing great work. Thank you, Joe.
Thank you, ChatGPT, my new friend.
I used to have another helper, but she's deserted.
I'll be back. I'll be back. I'm here. I told you I'm always here.
Okay, now if we go to page 16,
Okay.
That first paragraph there, just read through it. That is one of the most powerful paragraphs that you can have. Statement of claim to dismiss plaintiff's fraudulent claim on page 16.
Yep.
Yeah.
It should read, the plaintiff, J.G. Mann, acting malified, 7A of the Property Law Act. And it was just lucky that I went into court and heard that. 3 cases, he said, I have seen no deed of acknowledgement of debt. So the moment you acknowledge the debt and put a part payment in, what's the part payment?
$5 stamp.
$5 stamp. The bond will cover the rest of it anyway, but that is just showing them that you know what you're doing. Okay, so now we go to so the substantive law. You will find the substantive laws in your Crown proceedings, or it's proceedings against the Crown, I think, over there, or something like that.
Mm-hmm.
Okay, now we did do the maxims of law on page 20.
Nice.
Now, when you have done all that, then you must ask for what you want. Okay, so as all men equal under the law, our court being a superior court, now on this 4th day of April 25, issue this decree. Oops, what? A decree is higher than an order. So if you have a little giggle search for decree absolute, the dismissal of the false money claim and demand registrar, the Honourable Justice, in his or her private capacity and full commercial aid, to set aside false claim. Now, fiat justitia ruit caelum is let justice be done, though the heavens may fall. And then, now you're going to find something interesting here.
Oh, by the way, the equivalent of the Crown Proceeding Act in Australia is the Judiciary Act of 1903.
Okay. If you like to go into your into the chat there, you will find something that was given to me. Are you okay, H? You're not looking.
I'm okay.
You're okay? Okay.
Yeah.
It's fabulous.
Okay. Okay,
Fabulous.
now, fabulous. If you go into the chat and open up that document I just sent you through there, 2 witnesses. Now, this was given to me, and I can't mention this, but I'll put it in the chat. If you have 2 witnesses, once again, everything, and I learned this, everything is biblical. 1 witness shall not rise up against a man for any iniquity or for any sin. So sin is debt, for any debt. If you have 2 witnesses, it's a done deal, according to that very kind person. So I went looking and found all the references and have put it there for you in that document. Oh, and there you will find, Barry, on that document, answer provided by www.iask.ai has the burden of proving their claim. This means that the plaintiff must provide sufficient evidence to establish the facts that support their claim. The defendant may dispute these facts, and in some cases, the defendant may also present counter evidence to refute the claim. So now, there, in a civil case, which is what we're doing, it's on the balance of probabilities. Okay, it's not. What's the other one? Beyond reasonable doubt. That's in a criminal case, but in a civil case, it's on the balance of probabilities. So what I've given you there, that document with 2 witnesses, is just some of my study for that document. There's a whole folder full, but hold on, how many have I got? 1, 2, 3. Oh, no, give up. There's probably about 25 different acts. There's quite a few, isn't there, spammer? Joe got so excited with what she was finding. My bloody inbox was about 30 emails every day.
No, that wasn't me.
Oh,
That was Jerry.
between you, Jerry, and Dan, there was about 30 emails a day.
Oh, we've got to keep you on your toes. We're on the edge.
Indeed. All right. So what I have done, and at the bottom of that document, the affidavit, you'll see sworn and witnessed plus sworn and witnessed. So now if we have the 2 witnesses,
It's a done deal.
it's a done deal. Thanks, H. You got a couple of questions, Jay.
Yeah, I'm just trying to get the chronology going here. Now, you've got a statement of claim, which is typically 1, but this whole document starts with an affidavit, which is typically when you're starting to move motions.
No, just have a look at what it says on the. It'll be the 2nd page. So that'll be page 2. What does it say where the 2 lines go across the page there, Jay?
2 lines. Filed by John Henry.
No. There's 2 lines go across the page.
Affidavit in support. Affidavit in support of notice of opposition to strike out application. Right.
Okay. So that affidavit is in support of the document which follows it, which is the memorandum. Which will if you go to page 4, if you go to the bottom of page 4,
yeah,
and you see that sworn and witnessed plus sworn. Okay. Now go to the next page. Notice of opposition to strikeout application. So that's on page 5.
Yep.
And then I've put my memorandum, may it please the court.
Okay. So the chap, JD, whatever, initiated the proceedings. Then
Yep.
you said, hang on, they're fictitious and should be struck out.
Yep.
And then there's an opposition to strike out. So this is your response to that.
Yeah, he opposed my claims and said that they were worthless, and he's probably 100%
Naturally,
right, following their fictitious system. But when you because they don't get taught the law, they only get taught the processes. But when you apply the law, the judge must apply the law.
Yeah. So these happen in an order, but they don't. There's no hearing. There's
Sorry?
no hearing. There's no hearing. These just happen, don't they?
Oh yeah. So what will happen is when I put the affidavit in, I've got to put the affidavit because it took me a while to find a $5 stamp, but I'll be putting the bond in on maybe Tuesday or Wednesday because you're on holiday too, aren't you, over there?
Yeah.
Yeah. So when I put the birth certificate into the court, that will. I should never hear another thing.
Well, it's exciting times, and best of luck.
I don't need it.
No, this is great. I look forward to seeing the outcome, or rather, not seeing the outcome.
Yeah, well, you won't hear it. Look, they cannot, and you'll see that in my document. You won't find a court case like this because it would pierce the corporate veil.
Yes, I love that expression. So,
yeah,
that makes a lot of sense.
Where did you see piercing the corporate veil?
I think it was Law and Order, episode 16, season 8.
No, it was actually a movie. It was a movie. The Wizard of Oz.
Oh, right.
Remember where the dog pulled the curtain aside?
Yeah, right at the end.
Removing the curtain or the veil pierced the corporate veil.
Interesting. You know what you could do for fun? There are applications where you write subtitles. Honestly, like you could get like Pirates of the Caribbean, and you can literally just write the subtitles and give away all these little nuggets. I'd even do it for you. That'd be fun.
On your trot. It is so. Where's he gone? Oh, has he disappeared? Oh, there he. Oh, he's got his hat on.
He's back. He's now a pirate.
All
Bill
right, Barry,
Turner himself.
Hey?
Bill Turner himself.
Okay, Barry, if you want to wrap it up now.
Okay. Well, Bill, those documents you've been reading, where are they? Or they're the ones you sent to me the other day?
Yeah, and I can understand now why you were so quiet, Barry. You hadn't done your homework, you naughty boy.
Yes, well, I'll video them onto the end of this so people can read the documents. Okay.
Indeed. I will be putting them on the website as well, but yeah.
Yeah, I'll put them up at the end of this video. No, I'm just feeling shit-ass this morning. It's one of those days, But anyway, I'll get better with a bit of luck. A dial of prayer.
Right. God bless you.
Okay, well, we call it to an end. I will put the documents up on the end so everybody will know what you guys are all looking at. I'd like to thank everybody and some of the people I haven't met before, and of course I've met Jay and of course Rose and Bill for years. So thank you, Bill, for coming on. A lot of people will be very happy to see the skull and bones and yourself.
Indeed, it was a pleasure meeting you, Joe and Heidi, and thank you again, Bill,
And
sharing
hi,
some of your
Hedy. I've
time.
never met Hedy before. Okay, so we'll shut the recording off and then we'll say goodbye to each other. So London News signing off. Thanks everybody for being on this channel on Easter Monday, 2025. Believe it or not.
And thank you, Barry.
And you
Thank you very
too.
much.
Okay, we'll stop recording
Yeah.
and see what.